All right, State v. Martinez and State v. Bowden, a couple of merger cases, the same issue with different statutes. The difference lies in the statutes, so this can be fixed statutorily here. Question 1, does felony discharge of a firearm merge with attempted murder? The answer is no. Does felony discharge of a firearm merge with attempted aggravated murder? The answer to that one is yes, and we'll talk about why that is. All right, we'll start with Martinez. This case starts, as many tragedies do, at Denny's. So Martinez and his eventual victim, Rafael Cabrera. That's a guy named Rafael Cabrera. I guess he's a golfer, but it actually works really well with kind of the soap opera facts of this case. So we'll pretend that's Rafael. They worked together at a Tooele's Denny's for a couple of weeks. Rafael then went to work at another Denny's in Lake Point, which is also in Tooele County. And there he met Blanca, Martinez's then wife. Again, this is somebody that Google Images brought up when I put in Blanca. This isn't actually Blanca, but again, for the soap opera, it kind of works. The soap opera at Denny's. Rafael and Blanca grew closer as Martinez and Blanca's marriage fell apart. There's probably a twin in there too, and probably a gypsy curse or something. Yeah, so Martinez did not see this as a coincidence. He suspected, probably rightly so, that Rafael had moved in with Blanca and was stealing his wife and child as he saw it. So he started threatening Rafael. At one point, he made finger guns, I kid you not, at Rafael while he was having dinner with his family. And he also started spreading word around town. One day, he went to the Lake Point Denny's looking for his wife and his daughter. And victim said, well, I've heard that you're looking for me because you're trying to kill me. Again, you can see this soap opera scene, right? Trying to kill me. Martinez responded, no, not now or here at this moment, but I know where you and wife live, and sooner or later, I will kill you. Dun dun. You can just hear the dramatic music, right? Victim quipped, well, you know where you can find me. He got in his truck and he left. He wasn't too concerned about it. Probably should have been. A few days before the shooting, Martinez went to his brother-in-law's house and said he was going to kill Rafael, and he joked, as I suppose we all do from time to time, about killing people, and who hasn't, right? But this time he was serious. He even had a gun with him, and his brother-in-law was a little surprised, like, really? Seriously? Like, you're really going to kill somebody? For reals? Yeah, for reals. So the big night comes, and it really was, as they say, a dark and stormy night. So Rafael was on his way home from work when he ran out of gas, and he walked to a station to fill up a gas can, started walking back to his truck. As he headed back to his truck, there was an off-duty cop named Gino Garcia. He picked him up, just being a nice guy. He's on the way home from doing security at a jazz game or something. And he went in and parked behind Rafael's truck and turned on his hazard lights. And here's a figurative representation of what happened next. You see that one? Okay. As Rafael got out of the truck, he saw Martinez pull up behind them. And he tells Gino, the off-duty cop, this guy wants to kill me. Sure enough, Martinez got out of his borrowed car carrying a gun. Gino yelled at Sergio to get back in, and they sped off, with Martinez firing 3 shots at them. All 3 of those shots lodged in the passenger side where Rafael was sitting. So pretty clear intent of desire to kill, and a nice action showing his intent to do that. So state charges Martinez with attempted murder and felony discharge of a firearm. He filed a statutory merger motion arguing that both same act merger and lesser included offense merger applied. So here's the merger statute. Things merge when the same act of a defendant under a single criminal episode establishes offenses which may be punished in different ways. So it can only be punished under one of them. And then you have lesser included offense mergers. So the court, via Judge Christensen Forster, assumed without deciding that one of the merger theories would apply, but said that the legislature made an exception in the ag murder statute, so there's no merger. A separate subsection addresses felony murder, and the court said that if the predicate list applied only to felony murder, there'd be no reason to exempt them separately. So Martinez also argued that attempt crimes were different, but the court says no, attempt crimes were just derivatives of complete crimes, so no dice on that one. So that's the result in Martinez. Now for State v. Bowden, and that actually, I said aggravated murder, that was just murder. So same judges, different result on attempted ag murder. This is State v. Bowden. Here's Mr. Bowden. He seems like a nice guy. Somebody you'd want to have over for dinner, right? Yeah. Look at those dreamy eyes. Yeah. All right. So one day he stole a truck with a few guns inside of it. A few weeks later, an officer spotted the stolen truck at a strip mall. Bowden took off, and the officer gave chase. More officers came, of course, including Corey Tsourus. I think that's how you say his name, Tsours. Tsourus? Anyway, Bowden shot at him 6 times, striking him once in the chest. Fortunately, it didn't make it through his vest. So, yay, bulletproofing. The state charged him with attempted ag murder, 5 counts of felony firearm discharge, and a few other things like evading. Like Martinez, he said both forms of statutory murder applied. So the court rejected the lesser included argument based on State v. Corona, which came out last year, which said felony discharge of a firearm is not a lesser included of ag murder. So no deal on that one. But the court agreed on same act murder. And the state again argued, no, this is just an enhancement, like you argued in Martinez. But the problem is the language of the ag murder statute is different. So under 765202, aggravating circumstances do not merge with aggravated murder. The one that they relied on here was that the actor was previously convicted of felony discharge of a firearm. This was a concurrent conviction, not a previous conviction. So that was the issue there. Judge Harris concurred and said the legislature may wish to consider correcting the discrepancy between attempted murder and attempted ag murder for merger purposes. So I'm sure SWAP is on that, or if you have an idea about it, contact Jeff Buman like he talked about this morning. All right, now we need slide 503, please.
Oh, no, Bob. Run, John.
Stall.
Oh, okay. It's been a real pleasure to have this time with all of you today. We've missed the interpersonal interactions that we haven't been able to have for quite some time with our colleagues, and I just want to say that I appreciate it. We feel your well wishes out there, and we thank you for it. It's really nice to have Steve sitting here and Marilyn sitting way back there, but it's not the same as having you all in the same room. So we look forward to when we're able to get back to the Sheraton and doing this thing the way it needs to be done. But we're doing our best, and we appreciate you. How was that? Was that all right?
Well,
Yeah, thanks. All right, State v. Ray. Most of you have probably heard of this case because it got a lot of publicity at the time it happened. This is the Illinois law student who started chatting with a young lady online in Utah, flew to Utah, got a hotel room, put a bunch of rose petals all over the floor and all over the bed, and invited her over. And over the course of a couple of days, not all one continuous event, but different times each day over the course of a couple of days, they went to the hotel and engaged in various sexual activities. Shortly thereafter, she was taken to the emergency room for a vaginal infection, and that is when it came out that this is what had been going on. So the question here is, does action taken by counsel with no conceivable strategic basis necessarily constitute deficient performance? And this is the issue that John and I were kind of discussing earlier. Generally speaking, I would say that under prior case law, the answer to that question would have been yes. If there's no strategic basis, the court would have said deficient performance. However, the court now says not necessarily. So, why is that? Well, he was charged with multiple sex offenses. He was convicted of 1 count of forcible sexual abuse. He was acquitted on an object rape, and the jury hung on a couple of counts of forcible sodomy. The jury instructions included indecent liberties as a provision of an element of forcible sexual abuse, but did not define that term, and neither side argued for a definition instruction. Indecent liberties, so this is the statutory language from forcible sexual abuse, that you touch the anus, buttocks, or any part of the genitals or the breasts of a female person 14 years of age or older, or otherwise took indecent liberties with the actor or another. On initial appeal, the Court of Appeals found ineffective assistance of counsel for failure to object to that instruction without any kind of definition as to the indecent liberties. So here on appeal, we have Judge Paige Peterson, which, as you can probably guess, that's not Judge Peterson. That's actually Mary Lynn, and I don't even know how to say her last name, Reiskub? She's Chloe from 24. There's Judge Peterson. And it's a long day. On ineffective assistance of counsel, we've already been through this a couple of times. Deficient performance, an objective standard of reasonableness, and prejudice, or in other words, likelihood of a different outcome but for counsel's conduct. So at the time that this offense happened, indecent liberties did not have a statutory definition. It does now, but at the time it didn't. But the court had interpreted it to be something of equal gravity to the specifically delineated portions of the earlier part of the statute. And so the Court of Appeals reasoned that he should either have asked that be defined in accordance with the case law from the court, or that indecent liberties simply be removed, since neither side seemed to be relying on it. The court says, not objecting to an error doesn't necessarily constitute deficient performance. The court agrees that the term should have been defined under these circumstances, but reasonableness depends upon the facts of the situation, and basically that counsel doesn't have to fight absolutely every battle. And where indecent liberties was not something anybody was relying upon, therefore it was kind of a side issue that wasn't important and didn't really matter, then not having a definition for it also didn't really particularly matter. And so counsel deciding not to fight that particular battle or not to die on that hill seemed like it might be a reasonable decision. The ultimate question is not whether counsel's course of conduct was strategic, which again, when I read that, I was like that. The question is whether it fell below an objective standard of reasonableness. So even if the court finds that there's no even conceivable strategic reason to do something, if it's still not overall unreasonable to have done it or to have omitted to do it, the court's not going to find deficient performance. Strickland demands reasonable assistance, not strategic assistance. So, if there is a conceivable strategy to what counsel did, then the defendant fails in their ineffective assistance claim, but the converse is not necessarily true. Okay? So they acknowledge that their prior precedent has muddied this point, and I'd say that's a fairly conservative way to say what the prior precedent has done. I would say that this is the one that's muddying what seems to be pretty clear precedent up till now, but this is the direction we're heading, and it's a good one. It's a good direction. They say the Court of Appeals was not wrong for addressing the strategic analysis, but that finding none should not have ended the analysis with the Court of Appeals, and it doesn't end it here. In addition, the court, though, says, but we also just disagree that there was no strategic reason for what happened here. Basically, they say that a more specific definition of indecent liberties might have drawn more attention to that issue. And in this particular case, there was actually plenty of evidence of other acts that weren't the specific acts that were charged under, like the sodomy and the object rape, and even under the forcible sexual abuse, the theories on which the state was relying. There was a lot of other lower level sexual activity surrounding those acts that was more corroborated because it was things that the defendant had actually admitted to.
And let's not forget the biggest crime that he committed. He put on a Twilight movie.
He did.
During one of these episodes.
That's true. They cuddled and watched whatever it was, Breaking Wind or something. So, the court, having found a strategic reason, decide that Mr. Ray fails in overcoming the presumption that counsel's performance was deficient, but that even had they not found that strategic reason, they said it still may have gone his way on the overall reasonableness, because this was such a minor issue that it probably wouldn't have made a difference. There probably would not have been prejudice. So the holding, no ineffective assistance, reversed and reinstated, and they remanded it back to the Court of Appeals to address the other claims that they did not address originally, because this ended up being dispositive. All right. Oh, yeah, I guess I got two in a row. And then State v. Scott. So this case, I was actually trial counsel on this case. I was second chair. This is Tracy Scott, and this is his wife, Teresa, his late wife, Teresa. And unfortunately, they had a troublesome relationship that ended in her death. And on this particular occasion, it seemed to be over something fairly petty.
Stop looking at me, Swan.
That's kind of the long and short of it, and I don't mean to make light of it, but that's kind of what happened here. So the question is, what happened here was, during his testimony, Mr. Scott alleged that the victim had threatened him a couple of days before he shot her. He tried to offer that testimony. They started to go down that road at trial, and the state objected on the basis of hearsay. Defense counsel did not argue that it was not hearsay. And so the objection was sustained, and he was not ever able to actually put the contents of the threat into the record.
I don't know.
The problem here is that those contents never got into the record at any point. So we really don't know whether it was objectively unreasonable for him not to argue it, because we do know the record does not support exactly what the contents of that threat were. So they had a rough marriage. There was a lot of arguing and fighting. Sometimes there was physical violence in their marriage. At one point, Mr. Scott had tried to hit her with a car. On this particular occasion, Mr. Scott himself called 911 and indicated that he had shot his wife, and that by the time they got there, she was deceased. I mean, she was deceased almost instantly. He put one in her chest and two in her face. He indicated that earlier in the day, he had seen that their small gun safe where they kept their handguns was open, and that her gun was missing. Nothing much more came of that at that point, but he had noticed that. Then, at some point, he was outside in the yard, and he saw that she was watching him both through the window and through the kitchen, and the look on her face was not a good one. And in light of the fact that she had threatened him a couple of days earlier, he felt threatened overall about what was going on. And then he went inside and found that she was talking on the phone to her mom, with whom he did not have a good relationship, and the two of them were kind of laughing and mocking and sort of making fun of him. He marched into the bedroom. She was sitting on the bed, knitting and talking to her mom. And again, he saw, and this is the actual picture of the safe, the way that it was when law enforcement arrived. So it was pulled out from under that dresser where it had been. It was open, and then there was one gun and an empty holster sitting on the corner of the bed, just like that. Her gun missing, and then the gun that was there was his gun. He said that she was about to take a picture of him, or was threatening to do so with her phone. And so in a moment of rage, even though her phone had been found kind of tucked under her leg just like that, and based on the fact that she had threatened him earlier, he shot her. At trial, again, there was this hearsay objection as to the threat that was sustained, and with no response, the words were never put in the record. I'll tell you that the words, or what was explained to us by defense counsel as far as the contents of the threat, was that this happened on Friday. On Wednesday, she came home, having gone to the shooting range, and went up to him and said, "I've been practicing, and I've gotten my pattern down to a size about this big." That's my recollection of what defense counsel told us and the extent of the threat. And so I think as the analysis continues here, you'll see that once that gets into the record, hopefully this is going to end up going our way. Extreme emotional distress is what he was arguing as an imperfect self-defense. So again, this is not one where it would result in acquittal if the jury found it, but if the jury found that he acted under extreme emotional distress when he shot her, it would mitigate it down to a manslaughter from what would otherwise have been a murder. There was also, in this case, an Allen instruction, and John talked about that, the dynamite instruction, where at about 6.5 hours in, the jury was deadlocked. They sent a note suggesting as much. The trial court and we put together an instruction that went back to the jury asking them to continue, and about 2 hours later, they came back with a conviction and convicted him of murder. So the initial appeal, the state conceded that the statement was in fact not hearsay. Mr. Scott filed a 23B motion to go back, conduct a hearing, and get the contents of the threat into the record. But unfortunately, the Court of Appeals ruled without addressing that motion and without supplementing the record in that way. They found that it was ineffective to fail to argue that the threat was not hearsay because it was not being offered for the truth of the matter asserted, but for the effect on him under extreme emotional distress. and also that where the jury had been deadlocked at one point, that this was a close case that could have gone either way on the verdict, and that this, under those circumstances, this issue of the threat not having come into the record might have been the thing to push it over the edge, and so they felt like there was prejudice. On appeal here, and this is, I think it's Justice Peterson again? Yeah, so it's Justice Peterson, although this is Michelle Williams, who you may know from The Greatest Showman or Manchester by the Sea. And that's Justice Peterson. She says the sole issue here is ineffective assistance of counsel on the hearsay objection. The state requested a no competent attorney would have proceeded this way standard to be applied, which comes from a case Primo v. Moore. An amicus brief commented on that they said they have taken what was a daunting standard and turned it into an impossible one. The court kind of talks about whether that standard of no competent attorney is a new higher hurdle than the standard in Strickland, or if it's simply a synonymous statement of what the existing law already was. The Court of Appeals. Did I skip something? Okay. The Court of Appeals disagreed with the state that this might have been strategic. The state had argued and argues here that maybe the jury imagined something worse than the reality of the threat. And so maybe because the fact of a threat definitely came into the record. He mentioned the threat, mentioned that she had threatened him. It was only when he tried to actually say what she specifically said that the hearsay objection happened and was sustained. So the jury knew that he felt threatened and that she had made a threat. And so the state's saying, well, maybe the jury was conjuring something in their minds that was much worse than what the reality would have been. But without the threat, we don't have enough to decide. Oh, that's what it was. Okay, so on that last one, as far as the whether it was a new or higher hurdle, I knew there was something that I was missing there, but I couldn't see the bottom of the slide. They basically said that with no elaboration from the Supreme Court since that Primo case, that they're just going to go with the plain language of Strickland and kind of ignore this standard that the state was suggesting. The state also argued that even with no strategic reason, even if the court were to find that there was no strategic reason for not objecting, that wouldn't necessarily end the analysis, that that doesn't automatically make counsel deficient, which we found to be kind of what the standard is now. So the court agrees with the state under both scenarios. Without knowing the specifics, the court decides that it is impossible to conclude that counsel's inaction here was objectively unreasonable because we have no idea what the threat was, or the record has no idea what the threat was. Mr. Scott has to do more than simply claim that his lawyer made a mistake. They need to have made errors so serious the counsel was not functioning as the counsel guaranteed him by the Sixth Amendment. So as far as prejudice, the Court of Appeals had held that there was prejudice. But again, the court finds that depends on the contents of what was in the threat. The record here is insufficient, and that again, a weak threat might actually have harmed his case. So the court says that without considering the specifics of the threat, it's impossible to determine whether counsel was ineffective. It was error for the Court of Appeals to conclude that his performance was deficient, and prejudice can't be determined without the contents. So they remand it back to the Court of Appeals for a 23B hearing to put the contents of the threat into the record. And since, again, the ineffective assistance ended up being dispositive, the Court of Appeals did not address the Allen instruction, and so they're instructed to address that should they go a different way on the ineffective assistance claim.
That is a lot.
Sorry, that was lengthy.
Okay, Bob, let's go to slide 589.
589.
Yes, that's right. So while he's looking that up, a lot of prosecutors, I think, and defense counsel, in fairness, might look at the Scott-Ray standard and say, well, this was a big victory for us in our division because we've been pushing for a long time that the no tactical basis language from State v. Clark and other cases deviated from the Strickland standard. And this is the U.S. Supreme Court standard, so they get to say what it is, and this was just kind of superimposed on it. And some people might wonder, where's the daylight between no conceivable tactical basis and no reasonable attorney standard? And I think the difference that it makes essentially is not everything that counsel does has to be tactical or strategic. Counsel can reasonably overlook something. Counsel can reasonably make a mistake on something that's not central to the issues at trial. So I think that's where kind of the gap is between those two, but the court rightly aligns itself with U.S. Supreme Court precedent and says, no, there's even the language that Lance found so jaw-dropping about it doesn't matter if they're strategic, it just matters if they're reasonable. That's straight from a U.S. Supreme Court case. So they're the ones, it's their test under the Sixth Amendment, and they say what it means. Okay. This is a case about the worst scrapbook ever. Question: will the depravity of pedophiles always outstrip the imagination of the legislature? The answer to that will always be yes. I guess this is more of an existential question. The real question in this case.
By the way, John, you get the best question of the day for that one.
Woohoo! Get an award of some kind? A sandwich? I don't know, something. The real question is, how realistic do pictures of simulated sexual activity have to be in order to be prosecutable? Real answer, pretty darn, unless it has nude children in it and the context shows the necessary intent. So we'll talk about that. This is Mr. Hatfield. He doesn't look like a pedophile at all, does he? He was a middle school teacher in West Valley, actually. Of course, teaching students the approximate age that he was, we will see, lusting after. He was also a scrapbooker of sorts. Replaced pictures of camping and motorcycle riding with nude children and adults doing sex acts. They were taken out of context, so it's like cut a picture of a child out of something, cut a picture of adult porn out, and juxtapose them or make them interact with each other. I won't give too many details. This was my case, and some things you just can't unsee. They caught Mr. Hatfield because he took out his little scrapbook during his free period at school, and that school had cameras in all the classrooms, but he didn't know that the cameras also had audio on them. So even though he covered up the video, they were able to divine, based on the audio, what was going on. And so he was fired, and he was arrested, and they seized his scrapbooks. So he was charged with some misdemeanor porn on school premises counts that he doesn't challenge on appeal, but several counts of dealing in materials harmful to a minor. Here's the statute. 76-5B-201, child pornography means any visual depiction that has been created or adapted, modified to appear that an identifiable minor is engaging in sexually explicit conduct. This is often called the morphing provision. It's similar to a federal provision that basically takes account of, it doesn't have to actually show a real child being really abused. It could just show a real child that looks like the real child's being abused. And the question in this case was really one of, what would you call it? Resolution. How high resolution does it have to be, or how low resolution can it be in order to be prosecutable? Sexually explicit conduct means actually or simulated sex acts, including the visual depiction of nudity or partial nudity for the purpose of causing sexual arousal. So from Ashcroft v. Free Speech Coalition back in the early 2000s, we know it has to be a real kid. It can't be an adult that's made to look like a child, or an actor or something like that who is an adult. It has to be an actual child. But again, how real does it look like? This has to be the question here. So again, what has been seen cannot be unseen. Here's a description of the various pages. That second one was probably the most disturbing to me. I have this text bubble saying, "Is this right, mister?" And it said, "Teach her well," in all caps at the bottom. And again, this is at the middle school where he's teaching during his free period. This is, rather than brushing up on what he's going to teach in math that afternoon, this is the kind of stuff he's looking at. Some of them had pictures, nude pictures of children. I should say this. In some of these collages, the children were nude. In others, they were not. And they were all pictures of real children. There was no dispute about that. The pictures of nude children were not from pornography. They were actually from art books and One was from an art book, I know. I'm trying to remember where the other one was from. But they were taken from originally non-sexual contexts and placed into a highly sexual context. Let's put it that way.
Is he defacing school property? Books at the library?
I believe they were his own.
Oh, okay.
And some were from actually family photos, rating the family photo album. Quite a guy. So Justice Pierce drew the short straw on this one. He got to write. And we argued the resolution just has to be good enough that the average person can tell what's going on. So if an average person would look at the image that this person has put together and think, oh, that looks like an act of vaginal intercourse, or that looks like an act of masturbation, then that's high resolution enough. And the court disagreed, and frankly, it's understandable that they did. They seemed to want to punish it if they could have. This is from the opinion Justice Pierce said, to be clear, these images are disturbing and undoubtedly for sexual simulation, but we can't just apply the Potter-Stewart standard of knowing it when we see it. We're bound by the statute. So the upshot is, if you have like a deep fakes case with real kids, that's a very different story, and those are likely to be okay under the statute and constitutional, I think. So he says actual means actually happened. None of this actually happened, so we have to look at simulated. Simulated means duplicates within the perception of the average person the appearance of an actual act. So these are too rudimentary. If you remember State v. Butt a few years ago, that's where the guy was in jail and writing letters home to his kids, and in one section he drew a stick figure of himself naked, and there was enough detail in the stick figure to understand that he was naked, but the court just said that's too rudimentary to constitute dealing in materials harmful to a minor. But there is a different story on the nudity. So if you have a nude child in one of these images, it's likely to hold up to scrutiny here. To rely on the nudity subsection, it's the child, not the adults, who must be nude, because otherwise the child is not engaging in the visual depiction of nudity. Here, the images of nude children were clearly created with the intent to cause Hatfield's sexual arousal, and the children were engaging in nudity, so the court upheld those counts. So when you have that morphing or that deep fakes kind of case, as this sort of depravity becomes more and more sophisticated, look to State v. Hatfield. And slide 562 is next.
Oh, sorry, 562.
562. Yeah. All right, so State v. Heath, and again, a shout out to Ryan McBride in my office for this case. This is the story of the chiropractor who got a little handsy with some of his female patients. The issues here: admissibility of other acts evidence when a chiropractor is accused of appropriate touching, sufficiency of the evidence as to penetration on object rape, and this is going to get a little bit explicit in some of the language we're going to have to use to address this issue. So for the faint of heart, or those of you who've never done a special victims case, I apologize. Try to bear with me. And then jury instructions alleged to have been, quote, incomplete, legally inaccurate, and confusing. Dale Heath was a chiropractor, and this is what the factual basis said. When victim could not find relief from chronic back pain, her mom recommended that victim seek treatment from Heath, mother's chiropractor. From October 2012 to December 2012, victim, then age 20, saw Heath 9 times. The first 4 visits were mostly uneventful, though by the 4th visit she was starting to feel a little uncomfortable. Heath's conduct at the next 4 visits forms the basis of this criminal case. So one thing I think that Dr. Heath failed to realize in coming into this situation is that he was going to end up going toe-to-toe with one Ryan McBride. And what many people probably don't know about Ryan, although many people do know probably because it's fairly widely known within our office, and I would imagine the word has spread, is that Ryan has a secret identity. Again, we all know. Ryan's Captain America. He stands up for the rights of those who can't stand up for their own rights. He protects those who can't protect themselves. And that's why we find ourselves here with convictions on this case. So, visit 5. And we'll go through these kind of quickly because we still have a fair bit of stuff to try and get through here. She changed into a medical gown but kept her yoga pants on. He started to massage her inner thigh and ended up rubbing right on the seam of her pants, which was right over her vagina. She asked what he was doing. He said he was massaging her psoas attachment. She orgasmed during the visit but gave no indication that she had done so. And as soon as she got home and in the car, she cried all the way home. Visit number 6. Victim was in a lot of pain from her back and didn't want to believe what had occurred, so she went back. And the treatment that he had been providing, although what had occurred, it had also been providing her some back relief, so she went back. Same type of massage, but her sister accompanied her this time, and it looked like it was kind of moving in the same direction until her sister, who had left the room for a moment, came back into the room, at which point he just started massaging her thigh with both hands and conversing with her sister. Visit number 7. Again, still trying to convince herself that she was imagining things, that things were fine, that this hadn't happened. He began to massage her stomach, and this time he went lower than he had before, and he went under her underwear to touch her skin to skin on the outer portions of her labia. Excuse me. Visit number 8. Same as the last time. Massaging her stomach, went under her underwear and moved his fingers in a circular motion on the outer structures of her genitals. She then felt him clearly move one finger beyond those outer structures to the inner portion of her outer genitals and make direct contact with her clitoris. At that point, she still didn't tell anyone immediately, but about a month later, and that was her last visit, the 8th visit, about a month later, she told her mom, and they went ahead and reported that to the police. Dr. Heath, though, this wasn't his first rodeo. So he had a prior victim, JT, who was a massage therapist, and I think it was in 2012 that she went to him once for some hip and leg pain. And he began grinding back and forth on her crotch, touching and rubbing her clitoris. As a healthcare professional herself, she knew that that was not supposed to be happening, and he looked like he was enjoying it, so she ended the appointment and never returned. She also reported Dr. Heath to Doppel for what had occurred. Doppel, though they had some concerns, declined to investigate further or to take any formal action against Dr. Heath, but he did promise, as part of that communication with Doppel, to examine and adjust his practice so that this kind of thing would not happen again. Apparently he didn't do that well enough, because in 2015, EB went to visit him on 4 occasions. During the 3rd and 4th visits, again, he touched her genital area, including her clitoris, over her clothing. She said at first it seemed unintentional, but then after the 2nd time, she was very convinced that it was entirely intentional, and she also filed a complaint with Doppel and with the police. So in 2015, we have victim and then EB. Those are the 2 that happened in 2015, and then there was JT in 2012. The state charged Dr. Heath for both EB and victim, but the cases were severed by the court. So then we're just addressing the court or the case involving victim. Dr. Heath moved to exclude the other acts, that is to say, what he had done to EB and to JT. But under the doctrine of chances, the trial court said that those acts could be introduced, but only for purposes of mens rea, not for purposes of actus reus. As to actus reus, he felt that the state had failed to meet its burden to show some sort of statistics or frequency of false accusations against inappropriate touching among chiropractors. But as to mens rea, he said that rather than an overall statistical likelihood of this kind of thing happening in this kind of community, he said that inquiry has to do with the frequency of Dr. Heath's involvement in the accidental touching of the genitals of his patients. So the case went to trial. Another chiropractor testified about the standard of care and about how you can avoid touching or incidental touching of sensitive areas by draping techniques and physical blockage. He also said there's absolutely no medical reason based on what was being treated in these individuals for him to have been anywhere below the pubic bone. Heath also testified and said that any touching that may have occurred was unintentional, although he did acknowledge in cross-examination by Captain America that there was no reason to intentionally touch a patient's labia or clitoris. He was convicted of all charges. The court, interestingly, so one of the counts was object rape, based on the one occasion when there was penetration beyond the outer structures of the labia. The court sua sponte requested briefing as to that count on the issue of genital penetration and whether the testimony that came out of the touching of the clitoris was sufficient to establish the element of penetration. Heath filed a motion to arrest judgment in which he alleged that same thing, and also that the state had failed to show that his intent in doing any of these things was to arouse or gratify the sexual desire of any individual on as to count 4. The trial court, after briefing, ultimately rejected both of these arguments and denied the motion to arrest. He concluded that entry of the outer folds of the labia satisfies the penetration requirement and that the jury could have reasonably inferred the requisite intent from his other actions. He was sentenced to concurrent prison terms. On appeal, he makes the following challenges. 3 things. Number 1, challenges the admission of the other acts evidence, the sufficiency of the evidence on all counts, and as to the jury instructions generally. This was, the opinion is by Judge David Mortensen, and obviously that's David Chiklis from the Fantastic Four, the one in 2005, and The Shield. That's actually Judge Mortensen.
He was also the commish.
Oh, he was
That's
that's true.
That was a
Yeah.
great show.
By the way, Judge Mortensen was trial counsel or the trial court in Tracy Scott, which was the DV murder case we did a couple of slides ago, for whatever that's worth. Other acts evidence. So Heath raises 2 main challenges as to the other acts evidence. First of all, that it was erroneously admitted for mens rea. And second of all, that more of a generality, he just said it derailed the trial with irrelevant and prejudicial evidence. He also makes 2 additional arguments, that this should not have been admitted under the doctrine of chances and that it was error to allow it to show specific intent as opposed to simply showing some sort of general intent. The doctrine of chances has 4 foundational requirements: materiality, similarity, independence, and frequency. And frequency is the thing that's being argued here, that's at issue. With respect to frequency under the doctrine of chances, it can be used to show either actus reus or mens rea, and it depends on the purpose for which it's being admitted. Actus reus is going to go to the frequency of the particular type of loss. So again, more of an overall, statistically, how often does this kind of thing happen? Whereas mens rea, it has to be the frequency of the accused's personal involvement in this type of event. And so the analysis that the trial court did was exactly right. With actus reus, you got to show how often chiropractors get accused of incidental touching. Whereas with mens rea, you have to show how often Dr. Heath has been accused of incidental touching, and that's exactly the analysis that happened there. The court here agrees that the state satisfied the frequency requirement for mens rea. They say that for the average person, this kind of accusation would be a once-in-a-lifetime event. The court kind of questions whether maybe that's higher in chiropractors since they're touching people a lot more than most people do. But he said with the precautions that are available, as testified to by the other chiropractor talking about draping techniques and physical blockage, that they've decided that chiropractors are indistinct, and so it should still be a once-in-a-lifetime type of event. Plus, based on his history with Doppel and these other 2 allegations from these other 2 individuals, Dr. Heath was particularly on notice when this occurred. The court also said that frequency interacts with similarity, and the fact that these events, the nature of the touching was very similar, as was the pattern of progression over the course of a number of visits with each of these individuals, said that all of that weighs in favor of this coming in to support mens rea. And so the trial court did not abuse its discretion in admitting that evidence under these circumstances. Now, with respect to specific intent, so again, he argued that they shouldn't have been allowed to show his specific intent to arouse or gratify as opposed to some more general intent. He said it should have been to counter a claim of mistaken or accidental touch, but not for the specific intent. But the court basically says where this was not preserved and he doesn't develop the argument or cite to any supporting authority, the court's not going to do his work for him. So they declined to even address this issue. He then addresses Rule 403. Suggesting that this was minimally relevant, that the critical issue was the respective credibility of himself and victim, and that it should have been simply left to his testimony versus her testimony and their relative demeanors for the jury to determine who was telling the truth. He asserts without analyzing that the trial court's analysis ran afoul of Rule 403. Again, his failure to develop this argument, the court says he hasn't met his burden and declines to address it. He also challenges the sufficiency of the evidence on all counts. The court walks through each statute and each factual allegation and essentially says there's plenty of evidence that's been presented for each count, and none of his convictions require reversal on that basis. I did include all of those analyses in the written materials, so please feel free to peruse if you're curious. And then as to the jury instructions, he claims to have received ineffective assistance of counsel regarding the jury instructions, but the court, and he doesn't even say really what he actually challenged in the jury instructions, except to say that he paints it with a broad brush and has failed to meet his burden because he didn't specifically state what the issues were, just that he thought they were prejudicial and improper and illegal and a whole lot of other things that without really getting into the meat of it. So I don't even know exactly what he was challenging. But ultimately no demonstrable ineffective assistance on the jury instructions. So no abuse of discretion on the other acts, evidence was sufficient on all convictions, and no ineffective assistance of counsel.
Slide 640, Bob. This is an important single criminal episode case to be aware of because I know these kinds of things happen from time to time. State v. Cisneros. Thank you. All right. Question. If you rob someone of a car in Weber County, then drive to Utah County, is the possession of stolen property charge in Utah County part of the same criminal episode as the ag robbery charge in Davis? The answer here is yes. All right. Here is Landon Cisneros. He looks like he left a boy band 5 years ago and never quite got his life back together. He found a car on KSL for sale up in North Ogden, and he kept bugging the seller to see it. The seller was too busy to show it to him that day, so he said, well, this guy's texting me so much. Dad, why don't you just show him the car? So the victim's dad took him for a test drive, and afterwards the dad got out and walked in front of the car, but Cisneros opened the door but kind of stayed by the driver's door with the car still running, and he was on his phone telling whoever he was talking to how much he really wanted this car. He then jumped back in the car and started to leave. So the dad went and stood in front of the car, but Cisneros bumped him, and Dad decided, you know what, this isn't worth it. So he gets out of the way. Cisneros takes off with the car. He ends up down in Provo, where he's from, where he met some friends and started bragging about his new car. But unfortunately, one of those friends had seen a social media post about that car being stolen up in North Ogden and turned Cisneros in. So Cisneros ditched the car and threw away the keys, but they ended up finding him and the car. So here's the timeline. Utah County charges possession of stolen property and obstruction. The probable cause statement included facts about the robbery in Weber County. So they knew that this had been taken in a robbery up in Weber County, or at least that it had been taken from somebody in Weber County. So Weber County 5 days later charges aggravated robbery. Then he pleads 9 days later in Utah County to their charges. And then 2 weeks after that, he makes an initial appearance in the Weber County case and moves to dismiss based on the single criminal episode statute. He lost the motion in the trial court, but then entered a conditional plea. We used to call those for a long time Siri pleas based on State v. Siri from the Court of Appeals back in the 80s. Just cite Rule 11J now. That's in the Rules of Criminal Procedure, so you don't need to go to case law for it. FYI. So this is broader than double jeopardy under the Fifth Amendment. Here's the single criminal episode statute. The same or different offense arising out of the same criminal episode, so long as the offenses are within the jurisdiction of a single court and they're known to the prosecuting attorney at the time the defendant is arraigned on the first information or indictment. And single criminal episode means closely related in time and incident to an attempt or accomplishment of a single criminal objective. So let's see how that applies in this case. Judge Orm wrote this one. Conviction, he said, yeah, and he pled guilty in Utah County, so we've met that. Close in time, yes, just the time it takes to drive from South Ogden to Provo. Our office argued that this case was actually a lot like State v. Ireland from Utah Supreme Court back in the late 70s. What happened there is Ireland kidnapped a police officer and put him in the trunk of a patrol car and then drove his car 65 miles away where he robbed a couple of hitchhikers. And the court there said, no, those were, in Ireland, they said that those were separate because there were separate victims and it was separated in distance and time. The Court of Appeals didn't buy that analogy here. They said there weren't separate victims, there was just one victim. And the offenses were entirely related, possession of this car that you just stole, rather than going and kidnapping or robbing somebody else. So this was all of a piece here as the Court of Appeals saw it. And the single criminal objective analysis under State v. Rushton, the court also believed was met. The crime of theft by receiving actually started, they said, the instant the robbery was over in Weber County. So this started in Weber, ended in, and continued in Utah County until I guess he dispossessed himself of the car. But it was all the same kind of thing. Nature of the offenses, again, this was all about getting and keeping the car. The victims, arguably there were different victims here because the son owned the car and the dad was the robbery victim who was sitting there. But the court said the son was also a victim of the aggravated robbery because it was his car, even though he wasn't present. He'd still get restitution, right? If he was convicted in Weber County, he would have gotten restitution because he was a victim of the robbery. So they said, yeah, it's actually the same victims here. At least there's overlapping, same victim. And next in time offense, there wasn't any stopping and reflection between the offenses here enough to separate them out. Jurisdiction of the single court is an interesting one because you might read that and think, well, wait a minute, these happened in two different counties, so one would be proper in Weber County, one would be proper in Utah County. But the court said, and that's more a question of venue than jurisdiction, because you can waive venue, that's not jurisdictional. But the court says, well, second district had jurisdiction over both because he could have been charged with the possession of the stolen car in the place where he stole the car, which is true enough. And prosecutor's knowledge, again, the Utah County attorney, deputy Utah County attorney, had notice of the robbery through the probable cause statement. He knew that he or she knew that this was taken from somewhere else. So no big surprise there.
Oh, all right. 367. Please. Sorry, I know we're backtracking here. And this will be my last one, so thanks for listening.
And maybe the last one.
Maybe. Well, I'll try to be fast. All right, State v. Granados. Proof that you can miss something even with a machine gun, which is kind of amazing. So, on this one, a couple of claims. First of all, sufficiency of the evidence on attempted murder as well as possession of a dangerous weapon by a restricted person, and disqualification of a repeatedly sleeping juror without further inquiry. So, a number of witnesses saw a red Chevy Malibu driving around, and particularly the victim saw this guy doing something weird in his lane, and the victim kind of pulled up next to him, looked over, and as he did, the driver of that vehicle kind of reached up for something, and you could see that he had basically a whole sleeve of tattoos on his arm. When they made eye contact with each other, though, the defendant, or again, the driver of the vehicle, pulled out a gun and pointed it at the victim, who slammed on his brakes.
What are you doing? You're slowing down! You're slowing down! I'm bringing him in closer, Merlin. You're gonna do what? This is it, Maverick! I'm gonna hit the brakes, he'll fly right by. Shit, he's gonna walk on us! Now!
In the hopes that by hitting his brake that the Malibu would fly right by, and then he turned to try to just go in a different direction and completely get away from the guy. But he was not to be deterred, so he followed him down that street. The Malibu slammed on his brakes, turned, came back around, followed him down, and then slammed into his car, pushing the victim's car up onto some grass right in front of some townhomes. The defendant then pulled out a firearm and fired 10 shots into the victim's car. Witness number one heard shots, saw the defendant's car, heard more shots, saw him U-turn. He drove past her. She saw the damage on the car. The red Malibu had a baby on board sticker on the back. Witness number two, she was driving. She saw the cars collide. She saw him pull a gun out and shoot. Saw that there was a single occupant in the Malibu. Witness number three was driving. Saw the damage on the car. Saw the car on the grass. Described the assailant's face, saw him raise the gun and fire. He flipped a Yui, ran a red light, saw a piece fall off of his car. He stopped in the intersection, got out, retrieved the piece from the car, put it into the back of the seat, and then drove away. They found a broken headlight on the ground in the intersection where a piece had initially come off, and then when the defendant was later apprehended, they found the bumper in the back seat of his car. So the timing of this is kind of important. Officers had already been looking for Mr. Granados before this happened because the previous day his girlfriend had reported her maroon Malibu basically stolen, that he had it, didn't have permission to have it, and she was trying to get it back. So officers were looking for him and for this car. That day, the previous day, an officer had seen him alone in the car, tried to stop him, but he fled and they had to call off the pursuit. The shooting happened on this day at about 4:13 p.m. and then at about 6:15 p.m. another officer saw him in that same vehicle, identified it as him. And that's... What did I say down there? And again, they tried to pursue him, reaching speeds up to 95 miles per hour, but eventually they had to abandon the chase. But he did crash the car, fled on foot, and he was arrested, taken into custody. This is some of the evidence that was presented at trial in support of his conviction. The Malibu that had been taken that belonged to his girlfriend had a baby on board sticker. It was missing a bumper, and it was missing a headlight. Inside the car, officers found shards of glass that matched the broken glass on his window, as well as 10 spent .40 caliber shell casings. They also found at the scene, both in the 8 in the victim's car and 2 more in other places in the scene in the surrounding houses, they found 10 holes consistent with .40 caliber rounds having been fired. They found a couple of bullets and casings in the car, unspent. And then when they took the bullets and all the casings, put them all into one big jar, extracted DNA from that, Mr. Granados was found to be the major contributor of that DNA. Also, one of the witnesses did a lineup, and although she picked an individual who was not Mr. Granados, but that looked very similar to Mr. Granados, but she did not say she was sure it was him. She said that that individual resembled the driver of the car that she had seen. At trial, he moved for a directed verdict based on the sufficiency of the evidence. That was denied. On day 2 of the trial, the court took a break, told the parties that he had seen juror number 16 sleeping several times during the case. And this was very interesting to me. Defense counsel objected, and the court said he wanted to excuse her. Defense counsel objected, saying that he hadn't seen her sleeping and that they'd strategically selected her, which is interesting to me because anybody who's ever done jury selection knows you don't select jurors, you deselect jurors. We have to explain this to people all the time. Anyone who's ever done a trial has had to explain that to lay people, and why defense counsel says they strategically selected her, I have no idea, but that's what he said. At a minimum, the defense wanted to question her, and the trial court said, no, I've seen her sleeping. My staff has seen her sleeping. There's no need to question her. There's nothing she could say that's going to change that, and he excused her without further inquiry. Mr. Granados was subsequently convicted of all charges. On appeal, He challenges the sufficiency of the evidence, not challenging anything related to the subsequent fleeing or evading and stuff that had to do with that. He acknowledges that occurred, but as far as the person in the car on the day of the shooting, he challenges the murder, the criminal mischief, and the possession of a dangerous weapon by a restricted person. He also argues that the court exceeded its discretion under Rule 17G by excusing the juror without letting them ask her any questions. As to sufficiency, and this was Judge Jill Pullman, but again, that's Rose Byrne from X-Men First Class and FX's Damages. That's Judge Pullman. On sufficiency, the jury gets substantial deference. Reasonable minds must have entertained a reasonable doubt, and Granados challenges identity, though he acknowledges that it can be proven by circumstantial evidence. Circumstantial convictions are reviewed for any evidence, and an inference is reasonable unless no reasonable jury could accept it. So he says there are several alternative inferences to the ones that would have led to his guilt. But the court says we're not going to second guess the inferences that the jury made in this situation. All the evidence taken cumulatively is plenty to survive a challenge of the sufficiency of the evidence. As to the sleeping juror, Rule 17 says that if somebody is disabled or disqualified, that the case shall proceed using an alternate juror. There is precedent for excusing a sleeping juror. Granados says that the court couldn't determine if she was disqualified without first questioning her. The court says there's no hard and fast rule about that, and the court took several breaks just to accommodate that juror in the hopes that she would wake up. But between the court and the staff having observed her several times, they didn't need more information, and so there was no violation of the rule for not having questioned her. So sufficient evidence on the convictions and no violation of the rule for having excused the sleeping juror without letting counsel talk to the juror he'd strategically selected. Affirmed.
One more?
Okay, great. Let's go to slide 654. And we'll finish with these. A couple of really quick entrapment cases, just because they're kind of fun. Entrapment cases in general, and these cases in particular. State v. Hatchett and State v. Hernandez. There you go. All right, this in State v. Hatchett is an enticement case, and it starts in the classiest of online forums, Craigslist. So I Googled creepy old man, and this is the worst picture that came up that was not as frightening as Hatchett's actual picture. This is Mr. Hatchett right here. And he just kind of came out of central casting, didn't he? So, yeah, he was also dressing for quarantine before it was cool. So he posted an ad of a, quote, dad, meaning in parlance, applicable parlance, an older gay man seeking a relationship with a son or a younger gay man. He listed the age range as 18 to 25, and then an officer answered the ad asking, how young is too young? And the cop pretended to be a 13-year-old boy. They messaged back and forth about stuff, yada, yada, yada. They agree to meet together and have sex and do drugs and stuff. At one point, Hatchett says, you're not a cop, right? And the cop says, yeah, right, are you? I don't want to get in trouble. And then he seemed satisfied that this person wasn't a cop and resumed the conversation. This seems really common in these cases. I've had a couple of these cases where I don't know if they think the cop has to tell them that they're a cop. Like, this isn't a game of hide and seek and no, you found me. Anyway.
There's definitely some urban legend out there that says it kind of has to tell you the truth if you ask them a specific question.
Yeah, I've seen 3 of these in the last year, so apparently this is a thing that they do. But regardless, he shows up with drugs and a smile and gets arrested. He claimed that he had a hunch that Cade, the persona that the officer had, wasn't really a teenager, and this was all just a fantasy. And if there were a real kid there, he would have just driven away. That's what they all say, right? For those of us who grew up in the 90s and early 2000s watching To Catch a Predator people.
To be more careful about the real predators out there.
Yeah, right. He said, I'm here to warn them with all these drugs and alcohol and condoms that I have. I'm here to warn them about the dangers of creepy old men. Okay, so here's the statute for entrapment. what entrapment is and what entrapment isn't. There are a couple of examples here. I have Torres and Martinez. In State v. Taylor, Utah, 1979, a prostitute, heroin addict, snitch got her erstwhile boyfriend to go buy some heroin out of a sense of devotion to her. And the court said, look, she played too much on his emotions. He wasn't doing something because he wanted to commit this crime. He wanted to endear himself to his girlfriend, and she was just looking for somebody to ensnare so she could get more money, essentially. So there are examples of actual entrapment that you see out there from time to time. The example I have up there in the corner is Marion Barry, who was the mayor of the District of Columbia for a time. He was caught in a hotel room with cocaine and a mistress, I believe. I don't know if she was a prostitute, but it was definitely his mistress. And yeah, he claimed he was freebasing cocaine in a hotel room and claimed entrapment, but that didn't fly. So examples are, extreme pleas of desperate illness, close personal friendship, inordinate sums of money, appeals to extreme vulnerability. There's another famous case where this cop is down at Lake Powell and he just approaches random people and asks if he can buy marijuana from them. And when they say no, he just pleads with them, like, hey, I got to feed my kids. If cops are trying that hard, first of all, just go find a real criminal, right? And if you're trying that hard, you probably live in a pretty nice place. And you should go write tickets on something else because, anyway. So Hatchett said that because he hadn't shown any interest in minors, because remember his ad said he's looking for somebody who is 18 or older, up to the age of 25. He's saying, I didn't show any interest in minors, so police baited me into doing something I wasn't otherwise willing to do. And the court didn't buy it. They said, look, pedophiles know the law and will often make lawful advertisements seeking to lure minors using certain terms. They're savvy about this sometimes, right? And there was no pestering or emotional pleas here. He's the one who raised the possibility of illegal activity in the first place. And it's not a but-for causation test. It's about the methods and whether this person was willing to do it. Okay, last case of the day, and we'll be done. State v. Hernandez. This is Mr. Hernandez. One fine summer evening, he pulled into a shady corner of a McDonald's parking lot. Quote, this is from the opinion that was frequented by men seeking prostitutes. And I guess that gives new meaning to those golden arches, doesn't it? So an undercover officer approached him a minute or two later and asked him if he was, quote, looking for a date, which is code in that world for prostitution services, the court said. Hernandez said yes, and he asked her to get into the car. She asked if he had any money and what services he wanted. He said that he wanted to, quote, go all out and would make it worth her while. And to prove this, he pulled out, I kid you not, a $5 bill and some singles. So she said, in essence, that wasn't going to be sufficient. And they then agreed on a higher price. And she said, okay, go meet me by the 7-Eleven. Because, starting a date at McDonald's is tacky. So he was arrested at the 7-Eleven. He claimed he was entrapped, and the trial court agreed. Reading between the lines, it seems that the trial court agreed because the officer was just so darn pretty and that the time was so short. And, quote, the court said a significant number of people could be induced to patronize a prostitute if that opportunity presented itself. So this is a state's appeal. I don't remember what jurisdiction this was out of, but
Who's the judge?
On appeal is Judge Mortensen. Anyway, so the Court of Appeals reversed. This is Judge Mortensen. He said, first, look, even if the officer was attractive, according to the court, she was dressed in very dingy and unprovocative clothing. Second, they haggled over the price, and Hernandez had the chance to leave after his very lowball offer, right? And third, he had to go somewhere else to consummate this transaction. So the court said, and finally, the court did not buy that a person not otherwise inclined to patronize a prostitute would have been swayed or that there was any improper pleas here. So even if your judge thinks the undercover cop is just so darn attractive that nobody could possibly resist, here's a good case showing otherwise. And that's all we've got. Thanks for coming virtually.
All right, let's see. I'm going to join the brethren up here.
6 feet. Yep.
The roommates. Yeah, if you guys didn't know or couldn't tell, let's see, I think Bill's got me. Good. John and Lance used to be roommates, college roommates, if you couldn't tell. But we've appreciated them putting together today's presentation. I received a couple emails from our civil attorneys that are in the group. As we were preparing the survey, we forgot about you guys. Sorry. And so if you will email Ron Waite at rwaite@agutah.gov, letting him know that you're a civil attorney, and he will allow you to skip the survey and go immediately to your CLE. Just let him know that. We apologize, and we'll get that fixed. The conference evaluations, as I said, it will remain open. I mean, we'll probably leave them open for 6 to 8 weeks. So we've received some emails from people that are telling us the check is in the mail. Don't worry if you can't get your evaluation done today or tomorrow. We're working on that. We will leave the conference evaluation open. We will be back in the morning at 9 o'clock with our legislative update. And again, thanks to John and Lance, and for those of you and your patience as we work through this. So have a great afternoon, everybody. Thanks.